I am your presenter, Jingle Pan, and now we are going to discuss the Supervisor or Manager and Civil Rights, Equal Rights Amendment, Employee Rights, and Unions. So are you ready? Then let's start. So, some of the significant civil rights and labor laws are as follows, but we are going to discuss some of these laws in this discussion. So these are the laws and the civil rights that napumasa during those years. So we are not going to elaborate all of these laws since we are going to tackle some of this. Let us define what is harassment. So harassment is unwelcome attention based on race, color, religion, sex, disability, or genetic information. Harassment becomes a serious problem when the conduct of the individual causing it affects the employment, work environment, health, or general lifestyle of the individual being harassed. So example of harassment is halimbawa meron tayong boss and the boss is male and yung kanyang hinaharas is usually female coworker. So, kapag ka nahaharas yung female coworker, it can affect the female coworker in many different aspects, especially inside and outside of the work place. So that's an example of harassment. We have the sexual harassment as sexual harassment is a form of sex discrimination. It may include unwelcome sexual advances, requests for sexual favors, or physical conduct of a sexual nature. Sexual harassment occurs when submission to such conduct is either explicitly or implicitly a term or a condition of employment. Submission to or rejection of such conduct is used as a basis for employment decision, such as conduct interferes with the individual's ability to perform properly. The environment may become intimidating, hostile, or offensive. False accusation can lead to disciplinary action of the accuser. So, sexual harassment usually nangyayari to and we cannot uh, ignore this sexual harassments because it can affect the worker. Hindi lang siya nangyayari sa girls, it can also be happen to boys inside the environment. So pwedeng yung form ng sex discrimination is yung pwedeng sexual advancement, yung kapalit ng sexual favors para may magawa yung isang project or program. So that's an example of sexual harassment. We have the equal employment. Equal employment is the right of a person to be considered for a job on the basis of his or her ability to do the job. There must be no discrimination shown on the basis of race, color, sex, national origin, religion, age, Vietnam veteran status, and mental or physical handicap. So when we say equal employment, everyone has the right to be employed. So lahat merong fair chance to be employed. So that is the equal employment. Whether you're a girl, you're a boy, you're in the LGBTQ plus, kung ikaw man ay hindi, if you're white or you're black or anything, um, Catholic, Muslim, Christian, kung ano man yung age mo, we have the right for equal employment. We have the affirmative action. Affirmative action is an active effort to end discrimination and remedy the effects of past discrimination. Affirmative action includes taking specific steps to seek out, train, and promote women and minorities who will be included in all levels of the workforce. So in this program, they will hire a certain number of minority individuals, and this number is agreed upon by the enforcing agency and the organization. So in the organization where I belong to, uh, they are hiring during hiring season for the uniform personnel. They hire I think 10% ng hiring nila sa uniform personnel ay female. So they are giving parang habang tumatagal, they are increasing the percentage of female policemen to be hired during the process. So that is an example of affirmative action. Next is we have the seniority and discrimination. So there is a serious concern about the whole area of seniority because many minorities were not able to obtain employment in given areas. They obviously won't have seniority and therefore they are not the ones in line for promotions. So here in the Philippines, they are after the seniority of the persons to be promoted in a certain position. So example, since I am in the Philippine National Police, they are looking into the seniority of the person to be promoted. Doon nangyayari yung sinasabi nilang discrimination in some terms. So, on the other hand, minority individuals have suffered discrimination. And on the other hand, those who have been working in situation for many years have developed seniority status that had given to themselves. So, that is an example. Is we have the reverse discrimination. In certain areas, the so-called majority are now claiming reverse discrimination. They are saying that they are being denied access to medical schools, law schools, advancement, and so on and so forth because, for example, of their race or religion. They are saying that an individual should be given the right to all things in our society based on his or her ability rather than his or her surname, race, color, or religion. There are several cases currently pending in courts to determine just what acceptable in our society. So an example of this is the Bake case. Even though it did permit the gentleman to enter medical school, it is not a good base case, and therefore the whole question of discrimination versus reverse discrimination has not been. So the civil rights is the responsibility of the supervisor and the manager. So as a supervisor or manager, there are several concerns about civil rights today. They are the following. They must keep what is the right legally and what is required of the supervisor legally when any questions concerning civil right arise. He or she should repair this information to higher level supervision or the management. They must avoid going to extremes in any area and refrain from using passion-provoking words. Do not think that you can interpret the law or decide that the law is either right or wrong. It is not for you to judge. So improve your own attitude and your behavior towards all individual. Everyone has his or her own prejudices. So in civil rights, as a manager and or a supervisor, hindi ka pwedeng maging you cannot be above the law. So hindi ka pwedeng mag-judge if the law is right or wrong. You should know or you should repair the information regarding your subordinates to the higher level supervisor or the management. Clean up your language. Do not put people down and do not curse. These are not necessary. Also, be careful of jokes with the nasty punchline. So, as a supervisor or manager, you should always look for your language. You cannot discriminate the people. You cannot uh, put down the people around you using the words or the language you are using. Set a good example. And whatever discipline is necessary, always use due process. Hindi ka pwede mag-discipline lang basta-basta. You should always use due process. Here in the Philippines, the discipline that is na sinusunod natin is based on the uh, civil service law. We have the supervising minority members. So under federal law, the following individuals are considered to be minorities: the Hispanics, the Spanish surname Americans, Asians or people from the Pacific Island who are Oriental Americans, African Americans not of the Hispanic origin, Native Americans, Alaskan Natives who are Eskimos, and women. So the supervisor should look all the person as individual and not at his race, color, religion, or nationality. So you as a supervisor, you should not look at the individual because of their race. You cannot judge them by their race, color, religion, or nationality. You should look at the person as it is, kung ano siya as individual, as an employee, or as a worker. Because um kailangan nating i-recognize that people are different. They have different concerns and different backgrounds, different situation in the work, and we that can cause stress or threats to them. So you should, as a supervisor, we need to react accordingly in a nice and pleasant manner to our employees, because that is our responsibility. Next is age discrimination. Although older employees may start to slow down physically, they can continue to make numerous contributions to the job and to the organization. Since older employees as a group have fewer accidents, a better attendance record, a variety of experiences with work, plus a lot of loyalty, job skills, and steadiness. So in age discrimination, so kung makikita natin, older employees, especially those who are serving the organization much longer than those new employees, although they may start slowing down physically due to their age, but still they can continue to contribute to the job that is given to them. So sila kasi mas lagi mo makikita na they have the better attendance record, they have the variety of experiences in regards with the work and the loyalty, the job skills that they acquired through the years of service and steadiness in their jobs. So they may also be slower, weaker, and less resilient and suffer from a poorer eyesight than some, but it is wise to periodically reevaluate the jobs that the older individuals are doing and determine whether they are still capable of handling a particular job or should be assigned to something else. In any case, the supervisor manager should be careful about how or he or she works with older employees. Most individuals in the upper age levels tend to get more insecure as a result of becoming older. So, for example, if these older employees tend to be more sensitive compared to the newer ones, because sometimes because of their age, they are becoming more insecure. And as a supervisor, we should always reevaluate the job that be na dapat ibigay do sa mga older employees. When a younger supervisor or manager criticizes an older employee, it adds to his or her insecurity. Use the older employee's assets since they are important to you and the organization. Do not be afraid to ask an older employee for advice on how to carry something out or how to work with a variety of tasks and in situation. When an older individual is hired in a new job, if he or she has had past experience, it may take a little longer to learn the mechanics of the job. Although once this person has learned the mechanics, they usually stick with the job. Handicap employees, or what we call the PWDs here in the Philippines. So handicapped employees, despite their physical impairment, tend to be very fine employees. They generally have a better attendance record, are on time, and are reliable, and they are eager to do the extra bit that makes a good employee. Do not ever allow an individual's physical handicap, providing the individual is capable of doing a specific job, to cloud your judgment about hiring this person, as he or she may well become the best employee that you will have. So example, as you can see in the news or any on the social media sites, those here in the Philippines, they are starting to employ handicapped employees. For example, in some of the cafes in the mall, they use handicapped person. Kung makikita nyo minsan, sinasabi ng mga waiter or nung server, pakisulat po dun sa papel yung gusto nyong i-order kasi hindi nga siya nakakarinig. But still, they can do their job properly. We have the unions. So unions may be made up of unskilled, skilled, clerical, professional, and managerial people. People join unions for a variety of reasons, ranging from money and security to better and more stable working conditions, to power and the protection offered by collective bargaining. So understanding employees' reason can help management gain an insight into types of unrest and dissatisfaction that are existing and attempt to correct these conditions in order to improve the morale of the group and better achievement objectives of the organization. The right to join a union came in National Labor Relations Act or Wagner Act of 1935. The right not to join a union existed before 1935 and became a law after 1947, with the passing of the Taft-Hartley Act, which ruled the closed shop to be illegal. A closed union shop required a person to join a union before they could be hired. In a union shop, according to the law, in 50% of the states, a person had to join the union in 30 to 90 days after employment. In the other 50% of the states, you join the union if it already exists because it was part of the contract with the management. So in the US, it is illegal to join a union. In the past years, you should join a union before you will be hired, or if you were hired, you need to join in a union for 30 to 90 days after your employment. So it can be a group of unskilled, skilled, in anything in the people that has unions. National Labor Relations Board, or organizing a union. So the National Labor Relations Board is an independent federal agency that protects the rights of almost all the private sector and helps determine whether or not a union is legally being put in place. If people have complaints about unions, they can contact this board. The board is concerned about all aspects of employees' lives, including workforce, safety, necessary, family and medical leave. They help with matters of wrongful discharge or termination of employment, as well as the other things. The NLRB is concerned about youth labor laws and the protection of young employees. Young employees have restriction on the type of work they can do at the hours of the day they can work. They are also concerned about the number of hours per week and how much the young person should be paid to do the work. Safety and health standards for teens are strictly enforced and are part of the overall work. The NLRB is made up of 5 people appointed by the President of the United States to do the following. United States administer the National Labor Relation Act, determine proper collective bargaining units, direct and supervise elections within unions, prevent all individuals from committing unfair labor practices. Ruling of the NLRB can be overruled by a federal. To organize a union under the authorization and control of the NLRB, you must do the following. Get employees to sign an authorization card. If more than 50% sign, the union may seek voluntary recognition from the employer and file with the NLRB. If more than 30% but less than 50% sign, a request is made for a certification election. The NLRB investigates the petition to see if it is valid. If it is, a certification election date is set. Have a pre-election campaign by the union and the management. If the union received more than 50% of the secret ballots, the union is certified to bargain. Organize a union. The local union is of key importance in the labor management relationship. The local union represents the members of the bargaining unit. They establish a shop committee to work with the grievances, negotiation, and other union matters. The industrial relations system is made up of a management, union representatives, and the third parties. They work on contracts based on technology, the market, power, administrative structure, politics, public policy, and tradition. In negotiation, each of the individuals should be prepared to create a positive atmosphere, not argue about wrong or confusing issues, to avoid use of power, find mutual interests, and study the other person carefully. Unions and social issues. Traditionally, labor unions have been concerned with wages, fringe benefits, and internal management labor issues. However, in the 1970s, labor unions also become involved with minority employment, the role of women, the poor, and a large group of other concerns in our society. The supervisor who work in an area where unions are present must not only understand this concern, but he or she must also be able to work with the shop steward in order to properly carry out his or her role within the organization. So are uh, unions is almost everywhere in the government and even in private sector. So in the organization where I belong, we have what we call the NUPAD or NUPI, in which it is a unions form for the protection of the non-uniform personnel. So this is an example of unions and how they resolve social issues regard inside the we have the contract negotiation. All negotiation from contracts includes a variety of employee concerns. Some of these concerns are the degree of physical exertion required in the specific job and whether the physical exertion can be reduced, the degree of environmental problem which may contribute to hazards, the location of the work, the length of the work day and work week, the amount of specialization required for the job, the educational requirement for the job, and the experience requirement for the job, the amount of human interaction, and the amount of job responsibility and job freedom. Common misconception about unions. So they are neither socialistic nor communistic. In fact, they were very much against both types of government. They are most interested in sponsoring a form of government which will not only help them but also provide better things for their member. Many unions work with management in order to obtain better business relation and to make a bigger profit, which will enable union members to get a higher salary. The union moves into a part of management role when it attempts to advance the rights and interests of the employee. And so, as I have said a while ago, in the Philippine National Police, we have what we call the unions for the for non-uniform personnel, in which they are protecting the rights of the non-uniform personnels uh, for our protection. As we have the important facts about union. A union is a business. It is extremely big business. It controls vast amounts of money and has a vast amount of power. Union supports special hospitals, nursing convalescence homes, and many more other. And the pension plan operates effectively. So various types of unions. So may it come into direct conflict with the responsibility to the organization, and therefore the individual will not perform as intended in their role as a supervisor and manager. Unions of professional employees have been set up in hospital, colleges, and health department. It is important to understand that this unionization may increase in the upcoming years. Therefore, the organization will need to train the supervisor and manager how best to work and not to cause any conflict in the union. So next is the supervisor and the union. The first-line supervisor has a little or no direct involvement in labor bargaining and the labor agreement, since ang negotiate with the union is the specific person or even the big bosses or uh, the upper level management of a certain organization. Since this is carried out much on a higher level, so however, the supervisor is the official agent of the organization and therefore is held responsible for any action that involve employees or the unions. They must be familiar with the labor contracts with all the policies, practices, and procedures that make good labor management relationships. Unfair labor practices. So there are also unfair labor practices. The Wagner Act, which is also called the NLRA, or the National Labor Relations Act, describes the condition under which employee can bargain collectively. It does not set up any specific work condition. It merely states that employee can bargain for the wage, the hours, and the working condition. Previously, the supervisor could work with the individual employee without having to be concerned with the union and the union response to the employee's problem. Now, however, the supervisor may be charged with unfair labor practice if he or she interferes with an organization drive in such a way to attempt to force individuals to stay out of the union. So they may also be charged with unfair labor practice if he or she is involved in some form of disciplinary action against someone because of their union activity or union membership. It can cause additional problem when he or she is either neglects or ignores grievances, assigns jobs unfairly or neglects or ignores safety of or the other poor's working. The shop steward. So is in effect the supervisor of union members as it relates to their rights. This person's job is to guarantee that individuals are not denied their rights. So however, it is not to tell the supervisor or the employee what to do, how to do it, or how to operate within a situation. It is good for the supervisor to get along with the shop steward because cooperation is always better than disagreement. Equal Employment Opportunity Commission. So, USEEOC is the agency responsible for enforcing the federal laws that make it illegal for potential employers to discriminate against a person seeking a job because of color, religion, sex, including pregnancy, gender identity, sexual orientation, national origin, age, disability, or gender information. So it is illegal to discriminate against an individual who complained about discrimination. If any employer has 15 employee or more, typically this law will apply. So here in the Philippines, there is a law, I guess it is in Manila, in which they allow senior citizen to be hired again. Is the assessment. So for essay, these are the questions. So thank you for listening. Have a good day.